ವಿರುದ್ಧ ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ ಗವರ್ನರ್ ಅನುಮತಿ ನೀಡಿದಂತಹ ಪ್ರಕರಣ ಸಂಬಂಧ ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಸಿಎಂ ಪ್ರಕರಣದ ವಿಚಾರಣೆ ಸದ್ಯ ಆರಂಭ ಆಗಿದೆ. ಮೂಡಾ ವಿಚಾರದಲ್ಲಿ ಸಿಎಂ ವಿರುದ್ಧ ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ ರಾಜ್ಯಪಾಲರು ಅನುಮತಿ ನೀಡಿದಂತಹ ಪ್ರಕರಣ ಸಂಬಂಧ ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಸಿಎಂ ಪ್ರಕರಣದ ವಿಚಾರಣೆ ಆರಂಭ ಆಗಿದೆ. ನ್ಯಾಯಮೂರ್ತಿ ನಾಗಪ್ರಸನ್ನ ಅವರ ಪೀಠದಲ್ಲಿ ಸಿಎಂ ಅರ್ಜಿಯ ವಿಚಾರಣೆ ನಡೀತಾ ಇದೆ. ಸಿದ್ದರಾಮಯ್ಯ ಪರವಾಗಿ ಹಿರಿಯ ವಕೀಲ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ವಾದವನ್ನ ಮಂಡಿಸ್ತಾ ಇದ್ದಾರೆ. ಎಲ್ಲರೂ ಕೂಡ ಆಕ್ಷೇಪಣೆಯನ್ನ ಸಲ್ಲಿಸಿದ್ದೀರಾ, ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಅಂತ ಜಡ್ಜ್ ಪ್ರಶ್ನಿಸಿದ್ದಾರೆ. ರಾಜ್ಯಪಾಲರು ಆಕ್ಷೇಪಣೆಯನ್ನ ಸಲ್ಲಿಸಿಲ್ಲ ಅಂತ ಅಭಿಷೇಕ್ ಮನು ಸಿಂಘ್ವಿ ಅವರು ಉತ್ತರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದಕ್ಕೆ ರಾಜ್ಯಪಾಲರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಕೆ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ರಾಜ್ಯಪಾಲರ ಪರ ವಕೀಲ ತುಷಾರ್ ಮೆಹ್ತಾ ಅವರು ಹೇಳಿದ್ದಾರೆ. ರಾಜ್ಯಪಾಲರು ಯಾವುದೇ ಆಕ್ಷೇಪಣೆಯನ್ನ ಸಲ್ಲಿಸೋದಿಲ್ಲ, ಅವಶ್ಯಕತೆ ಇದ್ರೆ ತಮ್ಮ ಕಡತವನ್ನ ಸಲ್ಲಿಸಲಿದ್ದಾರೆ. ರಾಜ್ಯಪಾಲರ ಪರ ವಕೀಲ ತುಷಾರ್ ಮೆಹ್ತಾ ಅವರು ಹೇಳಿಕೆಯನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ.
I am not saying anything. I am only defending. Imagine Malut's to. That's why we say Malut's. That's why. No, there's another facet to it. In practical, not in law also, Malut's. People like the governor should be restrained. That's what happens when anybody walking about the path makes an application. Well, should not the governor have said that you don't require sanction? If you applied your mind. I'm not saying he would have or should have. Well, anybody on the road comes to him and says, give me sanction. He's so eager to give the sanction, the man himself says, no, I don't need sanction.
No, but approval under 17A is not sought prior to all actions. It is when the court proceedings were on, I guess, after the complaint being before the court.
Yes.
The approval is sought at the hands of the governor, not before that.
No, it's
When
not
was the complaint registered?
First, the sanction was sought.
Amal complaint registered. All right.
Right at the threshold. And your lordship, 3 mandatory judgments are prior sanction. So, Malas, this is Malas very serious. He's playing ducks and drakes, A with the governor, who has actually granted his prayer, and B with the court. And Malas, the only legal consequence of this is, of course, I'm not saying that he's going to withdraw, should be his withdrawal on the basis of his affidavit. He can't, Malas, the affidavit prevails. Perjury prevails on an affidavit. He can't be perjuring himself by filing the affidavit before your lordships. So on that affidavit, he must withdraw. Otherwise, your lordship should, Malas, treat that as non-est. The moment it becomes non-est, the sanction goes. So that's the ground for the sanction to go. It's not a suo motu sanction.
No, it's not.
Now, Malas. Now, the other person, like Alice in Wonderland, gets curiouser and curiouser. That is the phrase used, Malas, in that book. It's quite remarkable what happens in the other case. That is Mr. 4, R4. Well, he has got sanction also from the governor. Your lordship has got an order. The final order mentions, suddenly, notice came to me only for R3. That's why I actually.
A particular
4, 5
paragraph
also.
mentions these two as well.
These two also. So the governor is purportedly applying might to 4 and 5 also. But it now transpires that R4 never sought sanction. The other fellow says, I need not have sought sanction, but I did. I hope I'm clear. If you actually examine R4's complaint, which has now come to me, and I'm going to ask my learned friends better equipped in Karnataka to read it to all of
Maybe
you.
some restraint, my lord, on
Wait,
usage of words.
when sin is submitted, wait.
I'm going to ask you to read it.
Anything I'll ask you.
No, my lord. On usage of words, my lord. There may be some restraint.
About
my lord.
what?
Some fellow, Alice in the
that-
Wonderland.
yes.
My lord,
Sorry.
it's not, my lord. There's no impediment for me to use such words.
Yes.
But protecting the sanctity of this honorable
Yes,
court
yes.
is utmost important.
If
The-
literature of
I-
Alice in Wonderland
It's not a revenue
standards
court,
are
my lord.
objectionable,
No,
unparliamentary words, I
it's
plead
such
guilty,
like-
Willis. I
You may,
plead
you may
guilty.
address them as respondents, that's all. Yes.
Now, Willis, we are in a case where the first person says that I applied for sanction, but I need not have applied, which is sufficient to allow the sanction to fall.
All right.
The second person says, I never applied for sanction. Then how did the governor grant on
But
what?
he has not applied. That is a fact.
That's fact. Now we'll just see that. Just see that at 376, his application. It's quite remarkable. 5th of July,
Whose
2020,
application?
R4s. To the governor, which is now, well, we have got only well, with this reply,
76 of what?
376 of R4's objection.
R4 objections, madam. R4 objections. Yeah.
Now, Milits, I made them read it to me slowly, and I was happy to note that I could understand most of the slow reading of Kannadiga. But I can't read it to your lordship, so my learned friend Mr. Ravi may kindly do the honor of reading.
This
just
is
the
this Snehamai Krishna. R4, is it?
the last, just a relevant portion.
Just subject and
Yes.
the prayer.
First is the subject verse. Yes.
376. 376.
I'm sorry, I should Kannada.
All
I
right.
only said Kannadiga.
Hey, read.
Kannada.
In your subject ನೋಡಿದೆ.
Apologies.
When it comes to prayer.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
380.
ಅದೇ ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು
Yes.
Hmm.
I'll read it.
Yes.
My learned friend is also able to understand Kannada. When they read it slowly.
No, I understood when they read to me slowly in conference. I understood most of it. I was happy to note.
Yes, sir.
ಆದ್ದರಿಂದ ಈ ವಿಚಾರವನ್ನು ನಾವು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ವಿಜಯನಗರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ನಾನು ನೀಡಿರುವ ದೂರರ್ಜಿಯನ್ನು ಆಧರಿಸಿ ಕೂಡಲೇ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಹೇಳಿ ಮಾಡಿ ಸಿಬಿಐಗೆ ವಹಿಸುವಂತೆ ಪೊಲೀಸ್ ಮಹಾನಿರ್ದೇಶಕರು ಮತ್ತು ಪೊಲೀಸ್ ಮಹಾನಿರೀಕ್ಷಕರಿಗೆ ಸೂಕ್ತ ಆದೇಶ ಮಾಡಲು ಹಾಗೂ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ಪ್ರಭಾವ ಬೀರಿ ಮೊಕದ್ದಮೆ ದಾಖಲು ಮಾಡದಂತೆ ಮಾಡಿರುವುದನ್ನು ಸರ್ಕಾರಿ ಯಂತ್ರವನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸುಳ್ಳು ಮಾಹಿತಿಗಳನ್ನು ನೀಡಿ ತಾವು ಮತ್ತು ತಮ್ಮ ಕುಟುಂಬ ಯಾವುದೇ ಅಕ್ರಮ ಎಸಗಿಲ್ಲ ಎಂಬುದನ್ನು ಸಾಬೀತುಪಡಿಸಲು ಪ್ರಯತ್ನಿಸಿರುವುದನ್ನು ಗಮನಿಸಿದಾಗ ಸದರಿ ಪ್ರಕರಣದ ಮೇಲೆ ಮುಖ್ಯಮಂತ್ರಿಯಾಗಿ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರು ಪ್ರಭಾವ ಬೀರುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯನವರನ್ನು ಕೂಡಲೇ ಮುಖ್ಯಮಂತ್ರಿ ಸ್ಥಾನದಿಂದ ವಜಾ ಮಾಡಲು ಕಳಕಳಿಯ ಮನವಿ ಮಾಡಿದೆ.
Now, just this much shows I'm not interested in R4, who has not even filed. It shows complete non-application of mind of R2. Complete, total and absolute on that short ground, the sanction must go.
One clarification. No, 1 minute. One clarification. Here there is, he is not seeking sanction at all here. He's only asking the matter to be referred for investigation to the hands of the CBI. And inter alia, he says that he should step down.
Correct, absolutely.
So this is not a question of sanction at all.
Correct. He goes to the governor passes an order on this. Sends me a show cause based on this.
No, show cause notice is not issued on this.
No.
Not on
No
this.
show cause notice is
Not
issued on this.
Then, Malas, the order says I'm.
A paragraph
That's
refers
right.
to this.
That's right.
But no show cause notice is
No,
issued
no.
to you on this.
One of facts. This morning, along with a memo, we have filed a communication dated 31st of July 2024, which we have submitted, my lord, to the honorable governor, which seeks for sanction. Kindly see that memo.
When was that given?
31st of July. This is after this letter, another communication.
Governor's order.
That is what I want to point. So, my lord, to say
Governor refers to this, you mean?
by date, the governor, my lord, does not refer to it by date, but to say that no sanction at all was.
Why you did not file this along with the statement of objection?
No, Malas, I'm very happy. Please let them, Malas, oh, these webs we weave, we become Malas caught in them. Please record this. Kindly record this, Malas. This is an official statement. I'm not talking about counsel, I'm talking about his client. He says he did, so he said this is not, but I filed on 30th or 31st of July. Kindly record that.
Yes. No, anyway, it is getting recorded, not a problem.
No, what I mean to say is not record in that sense, but it's a stand now.
Yes.
Now, that 31st of July, so by my point till I heard Mr. Raghavan intervening was that there is complete non-application of mind by the governor. Now I hear him intervene, possibly to say, no, the governor did apply his mind. But my point remains the same. The governor in his sanction order does not recognize, mention or note 31 July, which I have heard for the first time 1 minute ago. So my non-application of mind is improved. Oh, these webs we weave. That is the point, fellows. That's what Shakespeare said. The more you weave a web, the more you get caught in it. So, to try and cure the lack of application of mind by the governor, a statement is made that we did give him a sanction application. The governor doesn't notice that sanction application in the order sent to me and does not issue me show cause on that.
No, all that the governor says at paragraph 2 is
Yes.
2 more petitions from Pradeep Kumar SP and
Yes.
Snehamai Krishna
Yes.
have been received at my office in respect of the same allegations.
So,
So
Manas,
date is not mentioned,
three
nor
things,
the
three
content
things.
is mentioned. Yes.
we do not know when given, how given.
So that's what now
Don't
is
know.
sought to be produced.
Now it is produced. It is quite astonishing, to put it mildly. That's my third sub point here. It is more than astonishing that a man who files a 100-page rejoinder forgot to say this in his counter, forgot to say this in his counter. At the moment, I'm trying to use words of studied moderation. We have all been mullahs, we are lawyers, your lordship has been a lawyer. There are lawyers all over the place here. A person who files a counter yesterday or day before has omitted to mention Hamlet in the Prince of Denmark or Prince of Denmark in Hamlet. But this is his complaint, this is a foundation. Till now we don't know about it. Your lordship doesn't know about it. Realizing that he is apparently curing the governor's defect, but not realizing that the governor doesn't tell your lordship whether he's acting on this complaint which I have read just now or the 31st July complaint. It is quite unclear. He has not, why should I not say that he acted on the complaint I have read to your lordship and not on this? Why should I not say it? And why is it not fortified by the fact that the first time this has been mentioned is on the 29th of August in the middle of arguments? Well, it's 31st July. When did I argue the matter first? I argued it 1 week ago, I think. 19th August, 31st July, 19th August, 29th August. In between on 27th and 28th August, counters are filed. Well, there are 4 occasions. I'm sorry, Balaz, I'm being a
So
little...
let's see whether the omission would cut at the root of the matter.
It would, Balaz, because this is a Balaz, your lordship takes a holistic view. No single straw breaks the camel's back. But Balaz, this
Yes.
is very, Balaz, to put it in the mildest word, is strange is not a good enough word, Balaz. This is amazing. And even taking this letter as it is, we do not know on what the governor acted. We are on the, ultimately, governor's sanction must go. Governor's sanction must go for all these reasons. We have no idea what he acted on, apart from, of course, never sending us a show cause. And that point I had made last time without knowing about this letter.
So you have to say that on this he asked for sanction. Just read the sanction. On this 376 he asked for sanction. Now he is getting intelligent and saying what. Just read.
Now, Malaz,
But one,
let me go.
sorry, one clarification.
Yes.
17A, does it contemplate issuance of a show cause notice against whom sanction is, approval is sought? Does it contemplate?
Well, it's
Application of mind will consider, but the submission that you're trying to make is governor has referred to these 2 and show cause notice was not issued.
it was
That-
issued.
No,
We also very-
only against
So
one
the
complaint.
principle
Whose
of issuing R3.
R3's
But the
complaint.
principle of issuing show cause is accepted by the governor himself.
No, true, but whether law requires is what I'm.
Therefore, Malaz, I would say yes, natural justice. Your lordship now, Malaz, has Malaz, let me digress for 2 minutes. For the answer, I'll be dealing with it separately. Let me digress. This is a direct question from the bench. I'm obliged to, Malaz, digress for 5 minutes and answer.
Yes.
Well, it's not now, but from 1967. Your lordship has this felicitous phrase, adverse civil consequences in
Yes.
Bina Pani Day.
Yes,
And your lordship did not have very big constitutional principles in 1967.
yes.
When your lordship elevated saying all this quasi-judicial, judicial, administrative, we go by adverse civil consequences. That is 67. Now, Malaz, your lordship has traveled a distance, 2 recent judgments, one of which I had the privilege to assist the court. That even, this is exactly the same argument raised, Malaz, that before you declare an account fraud, not Malaz NPA,
No, fraud.
fraud.
That has serious civil consequences.
This
Notice has to be there.
No, the argument was to declare it as fraud is like filing an FIR. You don't need a show cause. There was a specific argument of Solicitor General who opposed me. It's recorded.
That is.
Now, the FIR, you don't require a show cause.
No, FIR you don't require a show
The
cause at all.
argument is that before you declare criminal fraud, an account beyond NPA, you don't need natural justice. And the people in that batch, which we argued, were apparently allegedly owing hundreds of thousands of crores. The court set aside a batch on the principle of natural justice. My answer to my lords respectfully is that natural justice is now elevated to an Article 14. It's now part of Article 14, which is not earlier. Today, Malus, when you do something with very serious, the most serious adverse civil consequences, you are granting sanction to a public servant, in this case, the highest public servant of the state.
Approval.
No.
Oh, sanction is also mentioned.
No.
Yeah.
Sanction, oblique approval, let us call it. You are granting to the highest executive of the state, and you are yourself treating as show cause relevant, but you forgot to talk about the other guy. You did have Malus relevance in the first chapter. Therefore, Malus, you should have dealt with it. On balance, as of today, the law would Malus be interpreted in my favor. But here, Malus, I want something else. To come back to the point here, Malus.
No, I thought it fit to ask you that for the reason that no notices were issued on these two complaints is what you said.
Malus,
That's the reason.
The reason is this.
Yes.
That he felt that he had issued one. Malus, the reason is hurry and lack of application.
That's fine. Yes.
That's the real answer.
That
Let us be practical, Malus. The real answer is that.
Yes.
I got a complaint. I must proceed. So I issued notice on that complaint to him. I got two more. I said, I already issued a notice for one. I don't bother about all these technicalities of law. Let me pass the order as quickly as possible. That's what has happened.
All right. Well,
But Malus, I must now come back to this. This is
yes.
very, very interesting.
I wanted clarification.
No, I'll be
That's
dealing with that. I'll cite Dharampal Satyapal and Rajesh Agarwal. I'll
Yes.
cite those two judgments. Because the court has gone very far there on natural justice. Telling your lordships how important it is. Therefore, there are three, one more thing I want to say on natural justice before I come back to this. There are three categories. Category one is the category where expressly the statute excludes natural justice. There are many statutes like national security, atomic energy
Those,
plants. Your lordships there alone. The second category is where you expressly include natural justice. There is a third category which is the most interesting. The silence of the statute. Your
Then we
lordship
will have to
was-
read into the
In
statute.
Maneka Gandhi, your lordship quoted the very nice words of Hooper versus Wandsworth. The common law will supply the omission of the statute. That's the principle. In the interstices of that gap, you will read in natural justice. And this is, whereas nobody can doubt, is the most serious of adverse civil consequences. So you must read into this. Here the governor has acted on that basis. Only that he has not issued show cause notice on X and Y, but he has issued on Z. So there is no question about it in this case. But let me come back to this intervention by Mr. Raghu.